When it comes to contract law, you've probably heard two words thrown around a lot: fraud and misrepresentation. They might sound pretty similar, but trust me, in the eyes of the law, they are worlds apart. Understanding that difference is absolutely crucial, so let's break it all down.
So picture this. You've signed on the dotted line, you've shaken hands, but then you find out something you were told just isn't true. So what's the deal? Was it a calculated, deliberate lie? Or was it just an honest, innocent mistake? And believe me, the answer to that one question changes everything.
Okay, first up, let's dive into the deep end with the more serious of the two, fraud. We're going straight to the source, Section 17 of the Indian Contract Act, to see exactly what counts as a fraudulent act.
So what's the magic word here? What's the core of it all? It boils down to one single, all-important word: intent. If there was no intention to cheat someone, to trick them, to deceive them, it's not fraud. The whole act has to be a deliberate plan to fool somebody into a contract.
The law actually gets pretty specific and breaks this intent to deceive into 5 categories. First, you've got the false suggestion. This is the classic lie. A seller tells you a car has never been in an accident when they know for a fact it has. Next, active concealment. This is sneakier. It's not just keeping quiet, it's actively hiding something, like covering up a huge crack in a foundation with a rug right before a viewing. Third is the empty promise. Making a promise you have zero intention of ever keeping. The last 2 are basically catch-alls for any other tricky move designed to deceive, or anything else the law specifically calls out as being fraudulent.
Now here's where things get really interesting. We tend to think of fraud as something you do or say. But what if I told you that sometimes just saying nothing at all can be a lie?
Okay, so let's be clear about the general rule first. In most business deals, there's a principle you might have heard of: caveat emptor. It's Latin for let the buyer beware. Basically, it means a seller doesn't have to list out every single tiny flaw. The responsibility is on the buyer to do their homework. But that rule has big exceptions. Just look at this. On the left, you have a standard auction. Seller A doesn't have to announce that his horse is unwell. That's buyer beware in action. But on the right, the whole game changes. A is selling the horse to his daughter, B. That relationship creates a position of trust. He has a duty to speak up. And in that situation, his silence is just as deceptive as an outright lie. It's fraud. And here's another way silence becomes a lie. The buyer basically puts the seller on the spot. He says, hey, if you don't correct me, I'm going to assume this horse is perfectly fine. By staying quiet at that moment, the seller isn't being passive anymore. He is actively letting the buyer believe a lie. His silence is the same as saying, you got it, the horse is sound. And this just brings us back to the standard for most day-to-day business deals between equals. If one trader knows something about where prices might be heading tomorrow, they don't have to share that inside scoop. That's just having a competitive edge, not committing fraud. All right, so we've covered the deliberate lie. Now let's flip the coin over and look at its cousin, misrepresentation. This is all covered under Section 18 of the Act, and it's a completely different animal. And right there, what's the whole ballgame? With misrepresentation, that crucial word, intent, is totally absent. A false statement was made, sure, but the person who said it genuinely thought it was true. It was an honest mistake, not a devious plan. So, Section 18 breaks this down into 3 types. First is the positive assertion. That's when you state something as a fact, totally believing it's true, but you're wrong. For example, you tell a buyer a piece of jewelry is from the 1920s because that's what you were told when you bought it, but it's really a modern replica. Second, a breach of duty without any sneaky intent. Maybe an agent just forgets to pass on some key info, leading to a misunderstanding. And third, you can just innocently cause someone to make a mistake about what they're even agreeing to. Okay, this is the moment of truth. Let's put these two head to head. Seeing them side by side is the absolute best way to make the difference click. This is where it all comes together. I mean, look at this. It doesn't get much clearer. For fraud, the intent to deceive is there. The person knows they're lying. It's a deliberate, wrongful act. For misrepresentation, there's no intent to deceive. The person actually believes they're telling the truth. It's an innocent mistake. At the end of the day, it all comes down to what was going on in the person's head when they made the statement. If you walk away with just one thing today, I want it to be this question. Seriously, this is what it all hinges on. In any legal dispute about a false statement, this is what the judges and lawyers are trying to figure out. Answering this one question, was there an intent to deceive, is the key that unlocks everything. And look, this isn't just some boring legal theory. This has huge real-world consequences for you. Why?
Because if you've been a victim of fraud, you usually have more power. You can often cancel the contract and sue for financial damages. But with misrepresentation, your options might be limited to just canceling the deal. So understanding the difference is everything when it comes to protecting yourself. So, the next time you're looking over a contract, you won't just be reading the words anymore. Now you're armed with the ability to think about the intent behind those words. It's a powerful new way to look at any agreement you make, isn't it?